Okay, hello. My name is Nicole Kaloran. I'm the director of the Vermont Small Business Law Center at Vermont Law and Graduate School. I am here to talk to you with my colleague, Oliver Goodenough, about lending and financing for small business. This is part of the Vermont State Small Business Credit Initiative, or SSBCI program. This is a program that's intended to bring capital transactions and capital in general into the states for small businesses, and Vermont is taking part in that program. And we're providing legal education and services for that program. Got one more
And
person I'm going to admit here.
oh, great.
Yep.
And we
Okay.
might just quickly hear from our attendees who they are and what they're up to.
Yeah, I'm going to do that after we go through the agenda, and then I'll check in with
Okay.
everybody. We just had another person join us. Jason, just letting you know, we have a small number of people joining us today, so we anticipate this will be an interactive presentation. Would love to have you participate if you're willing and ask questions. All right. So I introduced myself. Oliver, do you want to introduce yourself? Go ahead.
Sure. I'm Oliver Goodenough. I'm a research professor at the Vermont Law and Graduate School and part of the small business program that Nicole is in charge of. And in addition to having taught business law, corporations, securities regulation, intellectual property, a broad range of business law topics, I also have been a founder, officer, director, and just recently an exit from a smallish to became medium-sized business and largely in the tech sphere, artificial intelligence assisted tech for investment advisory services.
And Oliver is here to be my expert because I am not an expert on equity and financing. I'm going to be filling in a little bit, but Oliver's our expert here, so he'll be able to answer some of our questions.
I've at least been through it with some success.
He's been through it. He's got experience as well as teaching it. So you can see the agenda that for how we're going to break this down. This is how we thought it might make sense to approach this topic. Again, we're trying to break this topic down in a way that both invites questions and establishes just a really general understanding of the process. What does debt look like? How is it handled? What are the distinctions? What are the different types? And what are the things that really a business owner needs to know if they're going to take on either debt or some sort of investment? That's the agenda. We'll go over at the end. How does one choose between borrowing or taking investment? That's something that we can look at the end, and that'll probably be an interactive discussion. So before we get going, I would like everybody, if you're willing, to introduce yourself and tell us what you're doing, what kind of business you're doing. And if you have any specific questions we can be helpful with today, please share those as well. Let's start with Jason.
There's two Jasons.
Oh no! Go ahead, Jason Carter.
So hi, so I'm Jason Carter. I was working on a business called Skip the DevOps. I'm kind of putting that to bed and looking around at some other opportunities, talking to one potential co-founder about a device in the apiary field.
Really? I would love to hear more about that.
Well, super early conversation, so there's not a lot to talk about yet.
Right. Yeah. Cool. Thank you. I was just trying to type that. So a device in the apiary sphere. That like I got to hear more. What are you doing with these bees? Okay. And you said Skip the DevOps. That's your name.
That was
okay.
Yeah, it's a business where basically it takes software that a software engineer will write, and it helps launch it into a cloud setting. And cool. It doesn't have a market the way that I did it. So yeah, I'm kind of putting that to bed. But
interesting. I can see the benefit of the idea. Just skip the DevOps.
Right.
What do you do? Okay. How about Jason? And I'm sorry if I mispronounced it. Jason Bellinger?
It's close enough.
Cool.
I'm Jason Belanger. I recently started mostly primaries like cybersecurity, consulting, but kind of looking at developing products into kind of how that relates to agriculture, like based around OT security and looking at some stuff into that realm. So again, still developing, but that's where I'm starting.
Cool. All right. And we have one more. I just got to scroll down. Stephen Ravelstad, how are you doing?
Yes, I'm doing great. So actually, I'm in Hawaii. My wife is a student here at Vermont Law.
Amazing.
So she's a second year, but so she gave me this invite.
Nice.
So I actually started a company called Megaterra Cybersecurity. We do incident response and cyber defense work. So like cloud security auditing. So as similar to what probably Jason knows there. We are up and running. You know, we have several clients on the East Coast. We're a small business, still with 5 individuals running the company. So this is a labor of love, and just looking for more information on, you know, potential financing. Right now we're debt free. We're running everything. It was self-funded by me to get it started. So a little bootstrapping, and yeah, looking for other options if we need it.
Okay, excellent. How interesting to get all three of you here from like the tech space, but it makes sense because about what we're talking about. Okay, cool. So I am actually going to start us off by looking at a glossary, just in case anybody needs definitions. I've tried to break some of these words down that you're going to be hearing during the presentation. If you hear it and it doesn't make sense, here's the glossary. And of course, I'm going to send this to you after the presentation. I apologize you don't have it already, or else you could reference the glossary when I reference it. Anyways, this is just, there's going to be some terms that might not make sense or that you might not be familiar with. You three seem like you might actually be familiar with a lot of the terms, but we'll get there. I'm going to hand this over to Oliver. Oliver, tell us about the difference between debt and equity.
Okay. First of all, let me just mention why are we even having this discussion? And I think, as each of you has said, businesses need capital. You know, the classic need for capital is to provide the money that will allow a business to get going and keep going. Sometimes, as it was mentioned by, I think it was Stephen, you know, you can bootstrap your way up. Use some credit cards, put a lot of sweat equity in, make it go. But for businesses, often you just need money. The business that I have just exited, I think we raised in the end $20 million in equity because, you know, we needed it. We needed to build stuff, and we needed to pay people, and we didn't have income yet, and we just needed to have that money. So for many businesses, even small businesses, you know, you're going to run a creaming machine in Vermont. You got to buy the creaming machine, and you can do it out of your own pocket if you got some money. Otherwise, you got to figure out someone who's going to help you buy the creaming machine. So we're looking at a circumstance where how do you get some money into an enterprise? And there are these sort of two classic paradigms: debt and equity. Debt and equity. Debt. What the classic indicia of debt are? There's an obligation to repay. You know, it's not money that you can just say, well, sorry, we lost it. They say, sorry, we want you and your house and everything else we can get our hands on. Because a debt is like renting money. It's like renting a house or renting a car. When you rent a car, you can't just go to the rental place and say, well, you know, I trashed it, it's gone, never mind. They want their car back. And so that obligation to repay is a defining element of debt. And one of the things that I know Nicole's going to spend some time on is what does that mean in terms of things to be concerned about? Because if you're the borrower, you just as soon have that obligation limited to some degree. And if you're the lender, you want it not only to apply to the borrower, but anybody else they can get their hands on. So again, it's that obligation to repay piece that's key. Another piece of it is that the debt paradigm is that it's some kind of defined rate of return. Commonly interest, but not necessarily. It can sometimes be variable. Sometimes there can be participation attached. You know, there can be different things applied by contract. But the classic paradigm is that some rental fee for the money, which we can call interest, gets charged and has to be paid as well. So that is a defined rate of return. What that means, though, is typically there's a limited upside. You know, if the thing becomes a unicorn, and the company becomes a unicorn and makes $1 billion, the debt people typically don't get any extra. They get their money back. They get their defined return, and then everybody gets to say goodbye to them. By the way, that again, there can be variations on that. There can be people who, you know, as a term of making a loan, ask for a warrant or some other kind of thing that would give them a bit of an upside in the company itself. But the classic paradigm says, hey, limited upsides don't participate in profit. Also, the classic paradigm says doesn't participate in governance. The lender doesn't get to vote on who's a director and things like that. Now there is some variation on that as well. Covenants can blur the line sometimes. Sometimes in a loan agreement there'll be a set of covenants, and those will say, "Hey, you can't do X without our permission." That's not quite the same as being on the board of directors, but it can get kind of close. We'll talk a little bit more about that later on. Also, there can be guarantees, there can be security, there can be recourse limitations. There's a bunch of variations that can go into this, expanding the ability of the lender to collect, or sometimes limiting it. So again, there's things like that. How do we document these? Typically, there's a loan agreement. Loan agreement will spell out the terms of the loan. Those covenants we talked about may well be in those loan agreements. There can be a security agreement if it's a secured debt, which Nicole is going to talk about a bit more. A note is how you represent debt as well. So typically in any debt relation, there'll be at least a loan agreement and some notes. Sometimes if it's a secured agreement, a secured loan, there'll be secured agreements and as well. So that documentation is mediumly complex at best for a business, can become quite complex if the terms of the loan become more complicated, and if there's a long string of covenants and warranties and things like that. Okay, so that's the kind of classic view of debt. Obligation to repay, defined rate of return, limited upside, doesn't participate in governance. There may be various things like guarantees, security, recourse limitations, and the documentation is typically that loan agreement, security agreement, and notes. Questions before I move on to equity? Any questions? By the way, we have a fourth person who's joined. We should ask them to introduce themselves.
That's
phone
correct.
Number,
Phone number 323. Who are you? Are you there? Can you unmute? *6 unmutes when you're on the phone. All right. Well,
All right.
if you want to jump in and participate at some point, we're trying to make this as interactive as possible because we do not have as many people as we anticipated, but all for the better. Okay. Any questions on the
equity?
debt? That's great. Move on to equity.
Next slide. There we go. Okay, so what's the deal in equity? Equity is a somewhat different idea than this renting money. This is really saying, hey, I'm going to join into the enterprise in some fashion by putting up some money. And the characteristics of that are, first of all, no obligation for repayment typically. You know, if the company goes down, it's risk money. It's money that is fully at risk. It's not money that is expected to be returned no matter what. So there is no obligation for repayment typically. Preferred shares and other preferences can give some priority to people, but again, that's priority when there is money to distribute. It's not an obligation to distribute. Open-ended return. There can be an open-ended aspect to this. Typically, if the company becomes unicorn, makes $1 billion, and I've got a 5% of equity, I just got $50 million. Woohoo! If I lent the company, I don't know, $200,000 and it was a loan and it went to $1 billion, I get my $200,000 back. If I've bought equity, typically there's no cap. Although that can be negotiated. Again, open preferred or contract can have more definition. There can be a preferred that has a capped out payment, for instance. It gets 10 million bucks back and then it just stops collecting. Open upside, subject to defined limitation. Again, the open-ended return, the open upside are somewhat the same aspect of this, but again, subject to defined limitations. Participation in governance. Unlike the debt piece, the equity investors typically anticipate some participation in governance, although that can be limited. There can be non-voting shares. There can be non-voting member interests in an LLC. That can be limited, but the starting point is an expectation that if I've bought equity either in a corporation or in an LLC, I'm going to have some participation on, perhaps in a defined way, on how it gets run, who runs it, all of that. Partnership or operating agreements are the documentation there. Typically, you get going. Stock definitions in the certificate or articles of incorporation. There can also be shareholders agreements. There's a whole set of different things that can be in this. If you're in a classic venture capital deal, there'll be 5 or 6 different agreements of all various kinds, adding up to 80 to 120 pages in length, all told. It can be very complicated. Or if it's just a simple LLC, it can be 5 pages and we're off to the races. So again, great deal of variety there in how that gets documented. Are there questions? Okay, anyway, I think it's important to have.
We're going to go into a lot more detail on some of this in later slides too, so you can always pause us there if you need to.
This is the onion theory of education, where you start out with an inner core and then you put another layer out, you put another layer out. So this is the sort of inner core of the onion on that distinction. You folks may be aware of these things, but it's, I think, important to keep in mind how that works. Because now we're going to dive in, take a deeper dive on each of the debt and equity. First going to hit debt, and Nicole, you're going to take that away.
That's right, I am. I'll pass it back to you for equity. So you can see here, and I'm not going to be able to watch the waiting room. I hope nobody else shows up while I'm doing my part of it, so it'll be fine.
You want to make me co-host, and then I can see?
Yeah, let me do that actually. Let's do that, because I'll need you to watch and see if anybody else joins.
Okay.
Let's see. Oliver, I will give you the power of the co-host. Excellent. Okay. So you can see here, really, what does debt look like? There's different sources for debt, and that's what I'm trying to highlight here. You can see I bolded the one that really we're talking about, which is contracts. It is also possible to generate debt for a business through torts by injuring somebody's person or their property, and it's possible to generate debts by having regulatory noncompliance. So all of those things make debt, as well as agreeing to repay somebody. But as Oliver said, the definition of debt is really the obligation to repay in some form, whatever the original debt was, whatever the original circumstance was. So what is the difference? What are the different kinds of debt? There are essentially these two kinds of debt: secured debt and unsecured debt. Secured debt is, let's talk about unsecured debt, actually. I should have put that one first. No, fix it, sorry. Secured debt is what you think about when you buy a house. It's what you think about when you buy some sort of a big piece of equipment. It's a large purchase usually, or some sort of financing of a purchase. If somebody can't afford to pay for something entirely, then they usually will take out some sort of a loan. The difference between secured debt and unsecured debt is that something secures secured debt. And that something is usually going to be the thing that the person or the business purchased. So if they bought a house and they needed to take out money, to borrow money to buy the house, they get a mortgage. If they bought a vehicle, they might sign a purchase and sale agreement, and there might be some sort of security interest in the vehicle that the lender gives, or that the lender holds. They can also be secured debt that ties into somebody's accounts receivable, for example. The thing that really distinguishes secured from unsecured debt is what rights does the lender have. If the lender has the right to take what is given for the debt, the collateral, then that's a secured debt. And everything else basically falls under unsecured debt. So that means loans, lines of credit, credit cards, no collateral given. The lender is basically, instead of relying on the value of the thing, they're relying on the borrower's creditworthiness and their cash flow. If it's a business. Distinguish that though between, so secured and unsecured debt is one thing. A guarantee also brings in another layer for debt. A guarantee is someone, whether it's a parent or a business owner, for example, which we'll talk about in a couple slides. A guarantee is someone agreeing to pay if the borrower themselves cannot pay or does not pay. So those things need to be understood. Anybody have questions on just the basic debt differences there? Some of this can get tricky. And how it's handled in bankruptcy usually follows, is it secured debt? Is it unsecured debt? And then there's different priority layers within those different categories. All right. What can the lender do if the debt goes wrong? Recourse is also different. The recourse really for a loan is to try to collect against somebody and to try to get them to pay voluntarily. If they don't pay voluntarily, then they go into collections. But there is the recourse that people need to worry about typically is going to be for secured debt if there's collateral in place. There's bad debt, the lender can take and sell the collateral. That's typically what happens. Think about a vehicle where somebody can't pay on the vehicle loan. The lender can come and take the collateral, which is the vehicle, at any time, wherever it's located. They can pick it up and they can sell it. And then the balance of what's owed becomes the debt of the person who owed the debt in the first place. So they do end up with the debt in the first place, but that is the typical process. Take and sell the collateral. There's a difference between full, limited, or non-recourse. Full recourse is where the lender, by contract, can take everything that the borrower owns, anything that the borrower owns, in order to pay the debt after the balances, after the sale is applied to the balance. Limited recourse means there's only specific things that the contract says the lender can take. And non-recourse, which is a lot of debts, think about a vehicle loan. The lender can't come and take someone's home or their personal assets. They can only take the collateral in a situation like that. So non-recourse loans are also, they're more common for items like vehicles. Why does it matter? Of course, as Oliver said, there's more risk based on which, if you're going with debt, if there's a better guarantee to the debt, that means it's secured debt, more likely to open up money, more likely to open up favorable pricing, but it's more risk for the business and possibly for the person who's running the business as well if things go wrong.
In fact,
Recourse can be
Nicole,
confusing.
may I jump in?
Go
for
ahead,
just one
jump in.
second about that? Which is that from a business owner's standpoint, it's generally preferable for that person to have the recourse be as limited as possible, for not to privately, to personally guarantee the loans to the company, that kind of thing. The ability to resist that can be limited, sadly, particularly in a smallish business. Frequently, a bank making a loan will say, and by the way, we're going to ask for your personal guarantee of that as well, because often the company will be a limited liability company or a corporation, both of which have no recourse through to the owners on an automatic basis. And the bank may well say, hey, we want to make sure we kept your attention on this by making it personally liable as well, or saying, oh, there isn't all that much collateral here. How about your house and a personal guarantee? Ouch. And again, these are things that lenders sometimes try and persuade small business people into. Think very long and carefully. Because essentially, when one does that, one is self-financing the company in a very, very exposed way. Yeah, people do it. Maybe what you have to do is say, I believe in this company. I need that $100,000. I'll put my house on the line with a personal guarantee, and there we are. The problem is, if it doesn't work, then the house and suddenly, not only the company fail, but maybe your house is gone too. So it is a tough thing to do, and well worth trying to negotiate limitations on, even in early stage companies where that's not always possible.
Yeah.
Anyway, Nicole,
Very good points.
apologize
Thank
for jumping
you,
in.
Oliver. No, that's great. Thank you. That added a lot to it. Does anybody have questions on this particular topic?
Not really. I
Okay.
do have a comment. Few years ago, my wife and I, we owned an actual gym, like a fitness gym, where we did personal training, and so it was about a 7,000 square foot facility. We did not have like a business history of it. We were just getting started, but we did have to use a personal guarantee to get a commercial lease to open the gym. We had all the equipment, but yeah, so we did do the personal guarantee there. It worked out in our favor, so it was a risk, but yeah.
Cool.
Yeah.
Well, I'm glad to hear it worked for you, because it can. And I don't want to say never do it, but I just want to say do it with your eyes open, because it can that can come and bite you.
Yeah, we
Yes,
sold
it can.
we sold the business during COVID. Someone gave us a pretty good offer to buy the
Nice.
turnkey business because it was profitable, even
Yep.
during COVID. So it
Cool.
worked out. Yeah.
Nice.
Fabulous. Well, good for you. Good for you.
Good for you. Yeah. On the subject of debt and entities, I just wanted to put a couple notes here. You've sort of made it clear already, but what do debt and business entities have to do with each other? A business entity is supposed to act as a shield for a person who's running the business, or the people who are running the business, essentially. So there's a difference between sole proprietors and just groups of people who are doing business together. That's the default. Is if somebody sells stuff on the side of the road. My child sells lemonade, they're a sole proprietor. That's what I put out there for an example. But that's just the person who is not incorporated, meaning they haven't filed anything with the Secretary of State. They have not set up an LLC or a corporation. They are exposed, as Oliver said. Not with regard to debt and what the lenders are going to take, but they're just exposed, period. They don't have any protection between the activity of the business and what could possibly happen to their assets. So somebody is running a business, they don't have an LLC or a corporation or a partnership in place or something like that. Somebody makes a mistake and someone gets hurt, or if they take out a loan and they don't have a business entity in place to protect them, their home is on the line, their personal assets are on the line, their bank account is on the line. That liability passes straight through to them. One of the reasons people have a business entity is to protect themselves, to make sure that activities of business go into that bucket where the business entity sits, that everything is separated between the person or the people running the business and the business entity itself. All those things have to be separated. And if they are properly separated, then there is limited liability protection from the debts of the business itself. There are, and you said covenants, backdoor restrictions on activity. That was your addition, Oliver. Do you want
Yes,
to take that?
I'm going to talk about covenants for a little bit, because one of the things that people sometimes, particularly if they're coming into it, a debt arrangement as without a lot of background, is that they don't recognize that paradigm which said, hey, when you borrow, the borrower is just an arm's length, and not they can in fact limit the activities of the company fairly significantly, even if they aren't on the board or officers or whatever. They have no direct control. What they do instead is say, okay, you can't buy any additional equipment without our approval. You can't pay a dividend or a distribution without our approval. You can't, there's a whole list of things that can't be done by the company. You can't buy new equipment. You can't buy real estate. You can't. All this stuff can give them a right of approval that is in effect a very strong governance right. It's better than any vote. It's like having 100% of the vote. You can't do it without our approval. So just be aware that that list of covenants is something that we as lawyers would pay some attention to. The business people sometimes don't. Sometimes they do. Sometimes they don't. And we would urge you as business people to understand that what that sounds like fairly technical. What are these covenants? Covenants are promises about things you're going to do and not do, and that can be a very limiting piece in that. If you got to go to the bank and get consent to buy a new piece of equipment, cool. But if they don't give that consent, well, where are you? You know, then they sometimes use that power as leverage over the business to get an approval of some kind. In bad battles of this, you just have to go out and get a new lender, which isn't always the easiest thing to do. Because if the bank is really tying you up or the other lender is tying you up, there you go. So it's worth understanding that while debt doesn't typically carry with it, governance rights in the sense of being on the board or anything like that, the covenants can be a backdoor way to be restrictions on activity that can be quite significant.
Yeah. There are limitations to the liability protections that a business entity provides. There's three main ones that we usually talk about. So this is something that lawyers have to worry about, because every mistake that we make is a professional mistake that we really have to have liability insurance for. But if the owner of a business makes a personal mistake and they hurt someone, they are not going to be able to escape being responsible for that mistake. It's sort of the analog in the tort world for when people get hurt to the agreement to take responsibility. So when somebody signs personally and they guarantee a debt of their business, as Oliver said, they're on the line. And whatever they put on the line to guarantee that debt, whether it's their home or their bank account, or hopefully not their firstborn, they can't agree to that. That is what's on the line. And that is not going to go away. That crosses the line essentially and makes sure that the business entity doesn't really protect the owner in that circumstance. They can agree to write it away. In other words, they can sign it away. There is also, though, a threat if a business owner does not properly separate themselves from the business. If they don't have, for example, an operating agreement for a limited liability company showing that there's an agreement between the owner and the business, that they're not the same thing. If they don't keep separate bank accounts with different transactions, or if those blur too much, then it appears when there's some sort of a court case challenging this, that there's really no distinction between those two. And so the court doesn't honor that distinction either when it comes to liability. So those are the ways in general that business owners can get into trouble, can either eliminate or reduce their limited liability protection from their business entity. Any questions on this stuff? All right, you guys are so quiet.
Any questions on sort of debt approach
on anything
generally?
Yeah.
This is kind of a lawyer's view of debt. A business person's view of debt is much more about cash flow and repayment and all that kind of thing. But these two intersect a bit.
I think it's next. I hand it over to you, unless anybody has questions so far. We're going to go into equity.
Okay.
All right, Oliver, take it away.
Hop over to equity. Woohoo! You need to give. There we go. Equity, as I've mentioned, is this method of exchanging typically money, although it can be effort and other things, exchanging something in return for a slice of the business with this upside, etc. And that slice of the business often says, hey, I'm an owner of the business. I own stock in the business. I'm an owner. There's arguments in the academic world back and forth whether that's actually an accurate thing, because when you own stock, you own certain rights in the business. You don't necessarily own the business itself. But that's an argument I'm not going to pursue here. because the equity approach says, hey, in the return for money, I'm getting more than just some kind of financial obligation. Typically, if I'm the investor, I'm anticipating a bunch of different things that I could have. I can have some control. I'm going to get some return. How are we going to define that? What's that going to look like? And this list here is my issue checklist for setting up a business, but also for creating it with an equity line. So first step in any of this is the formation of the business. Is it going to be a corporation? Is it going to be an LLC? What's it going to look like? And then the documentation of the formation often is where the deals get set up. So the stock structure of a corporation is where the deals on these and other issues get set. In an LLC, which is much more contractual, the operating agreement is typically where, again, those deals are going to get set, the deals on these issues. But these issues then are what recur over and over again. The first issue is, what are the people putting up? What are they giving? Is it cash? Is it a piece of equipment? Is it work? What is it they're giving? Is it to get them to have this right to receive some money back from the company? So the first defining issue is contributions. As we've been discussing in this context, typically it's going to be monetary, maybe real estate or equipment or something that's necessary for the business to go forward. It can be under most states' laws. It can be very variable. Most states will recognize even promises to execute labor can sometimes be enough to get some things. So promises can be enough, but more typically it's going to be something more tangible: cash, intellectual property rights, real estate, equipment, something that's being contributed. Second big issue is, okay, given that will typically entitle an equity participant to some share in the profits, some share in the money it makes going forward. And again, this can be widely negotiated. Folks sometimes have this notion that bright line numbers are necessary. They're often useful because you can make a deal on, hey, you get 25%, but it could be, hey, you get 2.3% of everything we get on Thursday. That would be sort of a silly deal to make, maybe, but it can be. There's a great deal of variation in what and how that share of profits can be defined. There can be caps on it. You get the first $2 million in profits, all go to you. After that, 50% to go to you until it's $4 million. After that, you don't get anything. So there can be formulas around this so that it doesn't have to be a bright line, hey, 25% of everything. Likewise, there's a share on dissolution. What do we get if the company wraps up or gets sold or whatever it may be? When the company is wrapping up, either happily or unhappily, what's when after everybody else gets paid, what do we get, and how is that done? That is often thought to be proportionate to the profit share. It doesn't have to be. It doesn't have to be. We can say, hey, you get 25% of the profits, but you're going to get 100% of the return until you're paid down, till you've got all your money back, and then we'll split the rest. A liquidation preference, as it's sometimes called, can be established. The point of this is that to understand that there are these paradigms and there are these bright lines, but they aren't. There's nothing that says it has to look like that. If you can imagine it, a clever lawyer can probably write it up in a way that's going to be enforceable as part of the deal between the folks who have the equity. Governance. Who's gonna run this thing, and how is it going to be run? The classic corporate structures have a board of directors elected by the stockholders. The classic LLC is to either have everybody run it or have a set of managers elected by the other members. Partnerships looking somewhat the same. Again, there's a very, very broad ability to define things. Mark Zuckerberg, right, with Facebook. Mark Zuckerberg stock. The stock he owns has 10 votes to the votes of shares of what everybody else owns. That's how he maintains control, is because he monetarily his stock may not give him this extra preference, but from a voting standpoint, it does. So again, we can disassociate those things from each other to create that. Sometimes we can have a shareholders agreement, by the way, which can back into some of this as well. Governance. How are you going to run it? Fiduciary duties. Fiduciary duties basically say that people who are in a position to control a company, officers, directors, and controlling shareholders or members of an LLC, owe each other a duty of fiduciary duties, which are basically loyalty, good faith, and care. And that means you got to, if you're in one of those roles, you got to pay some attention. You can't run the company just to put money in your own pocket. You have to run the company to actually benefit all of the stakeholders, the other shareholders, et cetera. Doesn't mean you can't make some money yourself. It just means you can't run it in a way that puts extra money in your own pocket. You can't do side deals. You can't do a bunch of stuff like that. Transfers. How do we bring in new members? How do we sell? How do we have an exit? How do we do all that? These are heavily governed by the documents. Why? Because let's suppose that we've got 6 people here online, right? Suppose we're running a business. You don't want necessarily me selling to somebody else. I mean, hey, I want to sell. I say this is a very fine person. This person has no experience in the business and is mostly not available to consult. But hey, does that matter? I
Great.
don't care,
Let's sell.
Money, what?
Don't sell.
Sell. Exactly. I'm getting money. You guys go. And you're stuck with whoever I sold to. So frequently, there's limitations on who can on who can come in. Those limitations are particularly strong in LLCs, but they can be built in corporations as well. And so that's the issue: is how are we going to restrict that? What are we going to allow? What aren't we going to allow? And the final question is tax. Because tax is Uncle Sam, although the rates have come down a little bit, but Uncle Sam and the states, et cetera, as a roughest estimate, get about a third of everybody's, if they're successful, get about a third of their sort of your 1/3 partner for life. And they're your business's 1/3 partner for life too. And how are we going to set that up? And we've got I think a slide with a little bit more on that later on, right? Or Nicole did that.
Yeah, I think, yeah, you've got a slide on LLCs and corporations and equity and tax.
I will hold off, defer on that till we get to that because it's a little complicated. Okay.
Actually, that's the next slide.
All right. And that overlays this question of of what do we do with all this? And there are really 2 major flavors of options in this. And one of them is the LLC or partnership. LLC is generally now preferred to most forms of partnership because of its limited liability aspect and its flexibility. If we think about the list of issues, we saw money comes in. Okay, we form it. How do we form it? We file with the state. How do money comes in? We define that in our operating agreement and the agreement among the various members. The money going out will also be defined there. The governance, who's going to run it? It can be member managed. It can be manager managed. It can have members, preferential members. Nicole gets to run it most of the time, but if we all gang up on her, we can make her do other things. Again, it's imagine an arrangement, and your lawyer can probably write it up. On the fiduciary duties, there's less flexibility there because folks, you can't waive some of those. Folks just owe a duty of loyalty. That said, we can get exceptions in particular cases. Entry and exit, again, we'll write that into the operating agreement and either make it restrictive or open or whatever it's going to be. We can build it in there. The tax. Whoo-hoo. The partnership approach to taxation is that everybody who's engaged as a member or owner of the LLC or a partner in the partnership, basically the entity isn't paid much attention to. The profitability of the entity or its loss is figured out, and that is passed through to the owners on a formula that will resemble their participation in profits and losses. And that pass through means that I then I have to pay the tax on it. The partnership does not, or the LLC does not. And also, by the way, I'm probably liable for my own Social Security and FICA and food of Social Security and Medicare, Medicaid payments. And those, by the way, can be significant, particularly if I'm paying both sides of that deal. That can be a fairly significant number, approaching even a third of the other taxation that may be on it. There's a wrinkle in this, by the way, which I'll come back to. Sometimes a partnership in LLC can elect to be taxed as a corporation. We'll see what that means in a few minutes. Corporation, again, list of issues. We can build it in frequently into the stock structure. We can also build it into a shareholders agreement. All these questions of who's going to vote, who's going to run it, what's coming in, what's not coming in. All of that can be built into into agreements or the stock structure. Again, if we're doing a venture capital deal, there'll be 50 pages of agreements on these issues, and including what the stock structure is going to look like in the certificate of incorporation, which is where that would be built in. These questions of sale, all these same questions need to be negotiated and then documented as we go forward. Tax. Now, what's interesting about the corporation tax is if the partnership view, the LLC view, was to pass it through as the baseline, the corporation baseline is to say the corporation is a separate taxpayer and its owners are separate taxpayers, its stockholders are separate taxpayers. And therefore, there was what has been called double taxation, because the corporate income gets taxed and then the individual income gets taxed if it's handed out as a dividend or other distribution. 2 or 3 things on that. It used to be that the tax rates were high enough that that was a strong penalty. The tax rates on the corporations, et cetera, have come down enough, so it's less of a strong penalty. Secondly, we can elect what's called an S Corp. What I've just described, the class corporation is called a C Corp. Why? Because it's subchapter C of the tax code. An S Corp comes into play, and the S Corp says, I am a pass-through entity, just the way you saw it with the LLC and partnership. Not just the same way, because actually there, a dividend paid may be tax-free, but it is not subject to the same withholding taxes, the Social Security and the FICA and the FUTA, that would be the case if it was an LLC or partnership. So it's a little better deal on the pass-through if it's an S Corp than if it's a regular corp. Regular pass-through as a partnership. That leads to this structure, and believe me, talk to your accountants about it before you try it. Leads to a structure that folks sometimes elect where they say, we're going to set up an LLC, we're going to elect to be taxed as a corporation, which we get to do, and then we're going to elect to be taxed as a S corporation if we qualify. So you put those 3 things together, and people, even with an LLC with a pass-through, can sometimes save on the FICA and FUTA. They can save the tens of thousands of dollars up to a cap and all. It's one of these things where it's not worth it for everybody. It's worth it for some people. You've got to allocate any distribution between salary and distribution. The salary is subject to those taxes. So anyway, it's a complex thing. Just be aware of it. If you talk to your accountant, they may suggest that if you're doing an LLC and suggest that it have this kind of funny set of steps. Another thing that, by the way, that sometimes applies is QSBS, Qualified Small Business Stock. QSBS is very interesting if the company qualifies, if the stock qualifies, and it's held for 5 years or more. And there's a sale, up to $10 million of that sale can be free of all federal taxes. Just isn't taxed. And Vermont recognizes this. I don't want to get too personal on this, but I have been a beneficiary of this, and it's very nice when you get to sell something there's no tax. So sometimes they say, "Oh, the C Corp has this double taxation. It's a problem." But when it comes to the sale of the stock, if all the qualifications fall into place, a big chunk of that can come back the other direction. Also should be aware that the taxation of options gets very tricky, and the taxation of defeasible stock, founder's stock, if it's subject to being taken away, that can also be tricky. Please talk to an accountant about that, because various benefits can be lost, and very significant tax penalties come into play if that's the case. Questions on tax, by the way?
In the situation of a partnership, you'd mentioned that, so as a pass-through. So let's say in a real world scenario, company makes $100, let's make the numbers low and easy.
Okay.
If I need to pay $15 as one partner, and my other partner needs to pay another $15, so that's around the third. Do we get a disbursement from the company in order to make that payment?
Not necessarily, not unless you build that in. No.
And would that be taxed if you did get the disbursement? So
it doesn't matter whether you got the disbursement or not. It's allocated to you. It's taxable. That's a good point. You can find you've got this sort of phantom income that you never saw, but you can get taxed on it.
Where do you take the dollars from in order to not get penalized? Like the bank account of the company, or
What a good question. That's something to build in, and a very good issue to bring up. Frequently, it's built into the operating agreement of the LLC or the partnership agreement. Excuse me. Saying, by the way, we'll have a minimum distribution of what's required to pay the tax.
and that's not then like the distribution is not then separately taxed as well,
No,
right?
the distribution is separated from the actual earning. The distribution is the money is, a little pot of money you pull out. The tax is on what was put into your pot of money as a result of but there's no necessary link between those two. The company's got to have enough money to make the distribution. If it doesn't have enough money, then it can't do it. And your capital account needs to have enough, or you'll get a negative capital account, which means that now you may own some money back to the company when it dissolves or when you leave it. I have a personal story on that, by the way, if that's okay, if we got time, is that I was once a partner in a law firm. I left that law firm to become an academic. We squared up everything. We thought we squared up everything. I took some money out. It was cool. Turned out I was still on some insurance payment that hadn't been trued up, and there was like 10 grand sitting there that had been expended on my behalf, which came out of my capital account as a result, and therefore I had this negative $10,000 that I was supposed to pay back to the company. To the law firm. My partners were kind to me because I was becoming an academic and I was not as flush as I might be. Nicole will understand that. And what they said is basically, we won't require the cash, but what we'll do is instead we'll give you 10 grand extra, and you're going to pay the tax on that 10 grand. So it's total paper transaction. I ended up owing tax on another 10 grand. I didn't know the whole 10 grand. I was grateful. They were okay. But yes, exactly that kind of way. I should mention, by the way, that in a sole member LLC, the starting point, by the way, is that or like a sole proprietorship, it's just a disregarded entity. It's just you. Now, you can get out of that by electing into corporation status, but unless you make some kind of election, a sole member LLC is going to be a disregarded entity typically. Whew. Other questions?
Heavy stuff, guys.
It is a little heavy. The tax piece, by the way, the tax piece is complex. We've just given an overview. Please go talk to an accountant or a tax lawyer to get some advice on what suits you and how to do it, and what might be the best way to structure. Because the classic thing is, hey, LLC is passed through, it must be better. And the answer is, it may well be, but it is not always. And there are things that can be done. So again, think of that list of issues, how those line up to these partnership and LLCs: formation, contributions, shares, profits, share and dissolution, governance, etc., exits, tax. Again, these map onto those companies either through the stock or through agreements in some fashion. But those are the issues to take into account. Okay, questions? Next slide. Where do we get money? Where do we get money? How do we do deals? One of the classic places is what's sometimes called the 3 Fs: friends, family, and fools, as the early stage investors. People you can go to, somebody who's going to give you. I had an uncle who always said, if you ever start a business, Oliver, I'm good for 10 grand. I never collected on that, but he always said it. He was both, he was a friend, a family, and a fool, probably all together on that thing. He had a little, wasn't wealthy, but he had a little money, a little extra, and he could do that. Okay. Yourself, you can bootstrap. I should put bootstrapping, which is basically, you can use your own money, or you can use your own efforts to bootstrap. Again, that's a source as well. Interested investors. Okay, how do you? Okay, yeah, some folks, they might come in. They sound like a good idea. Hey, I'm going to start a chain of gyms. I need $300,000. Maybe someone comes in for $100,000 and they get a 10% interest in the company or something. Okay. That's, by the way, often the classic LLC style of deal where you have a few limited investors. We tailor it to them. We can run it through an LLC. It's not going to be a national exit or something like that. There are some institutional places to go. There's the venture capital is a set of folks who venture capital is a place where folks try and invest in good deals, often tech, not necessarily, often medicine, some kind of thing that's going to be a high multiple. They're looking for a high multiple. They're looking to say, yeah, we're going to invest in 10 companies, 2 of which are going to be profitable, but those 2 are going to each be 10%, 100%, are going to be 10 times returns, and those 10 times returns will make me a profit and pay for anything else I lost. They, by the way, do a classic series preferred deal. If you end up with a venture capital and finance, there's this classic format called the series preferred deal, and that series preferred deal issues preferred stock in a C corp to folks who are going to take the ride and go forward. Private equity is out there. Private equity is kind of a little bit like your interested investors, only they're even more so. They're professional. They've got money to invest. This is what they're looking for. It's not the same kind of deal as venture capital, which is looking for this kind of long shot, early stage company. Hey, we'll take the ride and see. What the private equity typically is looking for is something a little more mature, ready, some income, a deal that's going to carry them forward and have some growth, but it's not going to be, they're not going to be the desperate growth or growth or die folks that a VC deal typically is. They may come in through an LLC. They may come in through a stock deal of some kind, often a preferred deal as well. Now, one of the wrinkles on this is, when will investors want involvement? When do they want to be part of the deal? And the classic VC deal says, we're going to have a member of the board of directors. We're going to be to some degree involved. And the private equity deal probably says that. Your friends and family don't necessarily. The interested investors may, again, think back to the control, governance, all of those questions that we saw. How is that going to play here? And be aware also that in addition to actually granting stock, sometimes we can grant options to have it. The folks who work in a business can often have options, which are the ability to buy. They're not actually going to invest, but the company's going to give them the right to buy at a certain point. Typically, if there's a good, decent exit kind of thing is the point there. And then there's always an option price, which has to meet certain tax requirements. And that option price needs to be either paid to buy it, or it has to be will be deducted on an exit on a deal. Owner equity, again, that's there. But there's some tax implications there. And owner equity is nice, a place to start. I have personally participated through owner equity, which is a very nice way to do it. I've also had options which are less nice, but not bad if the exit price is decent. So again, there are different ways of doing all of that. Whew. Questions? Does this map onto people's experience and expectations? Last wrinkle is the next slide. Is the SEC and blue sky layer. There's a lot of things one needs to worry about. The SEC, if you're raising money, SEC and blue sky is a typical thing to worry about, particularly if the company is raising equity, because the SEC, Securities Exchange Commission, is set up to govern the sale of securities. And while securities equity is not the only form of securities, debt can be securities as well. Equity is very typically a starting point for what is a security. And in addition to the feds, there's a state layer. It's called the blue sky layer, and the blue sky is a set of state laws on this that can be either paid much attention to or opted out of to a significant degree, depending on what's happening. And the starting point for all of this, and particularly on the initial raising of capital rather than the subsequent trading, which would be the 1934 Act, is the 1933 Securities Act, set up after the Great Meltdown of '29 in an attempt to ameliorate some of the problems there. The core thing of the 33 Act says is you cannot sell securities, which would include these equity and debt, to some degree debt if we're syndicating it. We cannot sell securities unless we have an effective registration statement. And an effective registration statement is typically at least 40 pages long, and more likely a couple hundred pages long. And it costs anywhere from several $100,000 to several $1 million to put together. Huh? How do I raise capital if it says I can't sell stock as an issuing company unless I spend $200,000? And the way is basically that there are exceptions. And the key exceptions are, one, a Section 4A2 exception, which basically says the statute says that issuers can sell securities without registering them if the sale is not a public offering. So a big question is it a private offering? And the statute doesn't define, Nicole had that nice list of definitions at the top. The statute does not define what a public offering or private offering is here. It just says if it's not a public offering. There's a bunch of court cases which give some guidance, and the basic approach is if you're selling to a limited number of people without advertising and you know them already or through some close connection, it's probably not a public offering. If you're selling with advertising to a lot of people and a lot of people you don't know, it's probably a public offering. Okay. So that's kind of the line. Because there's no definition, lawyers are often a little scared of 4A2. By the way, if you are doing 4A2, by the way, all of the blue sky rules apply. So then you have to go and look at each state where you're selling to one of these folks. And then you have to say, okay, under this state, am I exempt? Do I have a filing? And what do I have to do to make a 4A2 deal work at the state level? By the way, you are spending tens of thousands of dollars on your lawyers, or you're self-educated and doing a lot on this. But at least it's not hundreds of thousands of dollars on your lawyers.
We can help with a little of that. We can offer 10 hours, but it's not $10,000.
we can give you a start. We can give you a start.
Yeah.
And Reg D is a defined exception because the SEC said, people need some definitions. And Regulation D says, by the way, here's a regulation that spells out the requirements, what you got to deliver for documents, what exempts you from that delivering documents, all the stuff that would be good to know about. And it's a roadmap to compliance without going the whole hog of a public offering. Regulation D. And under Regulation D, there's a concept called an accredited investor. And accredited investors are companies and banks and things with reasonable net worth, $10 million or so, something along that line. It's also individuals with high levels of income, or individuals with reasonably, I won't say high levels of net worth, but a reasonable level of wealth. It's a couple $1 million. It's not a lot of money. It's the income is a couple of $100,000. It's not a lot of, okay. It's not trivial and puts people up in the 5%, but it doesn't put them in the 1%. And so the advantage is under Reg D, if you're dealing with accredited investors and you're coming under 506, almost all the requirements disappear. Not quite all, but almost all the requirements for documentation, the requirements for a bunch of stuff go away. You still can't advertise to the general public, although under 506B you can to some degree. Anyway, there's 506C by they can to some degree. There's a bunch of fairly technical rules in there. 504 is another approach, but 504 doesn't have the benefits of getting rid of most of the requirements. The requirements are still partly there, and it throws you back into blue sky. The other benefit of 506 is that in addition to if you're accredited is getting rid of most of most, but not quite all of the requirements, is that you can file the 506 form, a Form D with your state people and just say, state people, you're on notice, here's some money, go away. So it makes blue sky compliance really very, very straightforward and simple, which is a good deal. Whew. Questions on this SEC stuff?
Oh my goodness, you guys, I've been listening to this Oliver talk about this for years and I still get confused.
The key piece is take this seriously. If you're just raising a little bit of capital from a few people it's probably fine, but if the minute a syndicated deal of some kind with people that the company doesn't know or the promoters don't know, as soon as that kind of classic, investor raising thing goes forward, time to talk to a lawyer about this stuff. Because this can bite very deeply. The penalties for not doing this can be significant. They can mean giving back everything. They can be criminal. There's a whole ton of penalties that come into play here that are just not worth getting involved with.
Jason, did you have a question?
I did, but I answered my own question. I was wondering the 504 of what? I'm sorry,
it's 504 Reg D. It's a Reg D. Yeah, 504 and 506 are subsections of Regulation D, which runs from Section 500 of the regulations under the 33 Act up to Section, I think, like 510 or so.
And these are all rules listed on SEC.
So, and these are part of CFR, is that right?
Yes, the Code of Federal Regulation.
Okay, yeah.
Yeah. And in
So
fact,
that's your,
these are the SEC's numbers, the 504. If you go to the CFR, they get a little more complicated than that. But this is they're typically called 504 and 506. Yes, my apologies for not making that clear.
is there guidance on the SEC? Is there like online guidance from the SEC about these different things?
There's all kinds of online guidance on this stuff. Problem with the government guidance, this is often relatively technical and not necessarily open to entry level folks. But there's entry level stuff out there. There's a ton of online resources on this. Much of it quite good. You do want to be a little careful not to just believe everything you read, but much of it is very good. And if you turn Chat GPT or some other AI loose, again, mostly going to be good, but there will be a mistake someplace. So make sure you check it. Let me think. So, by the way, let me talk very briefly about incubators, because incubators are places that you may have some experience with. Incubators are places that often help sponsor. Sometimes they take a little piece of the action. All right, well, there we go. But they sometimes will have lawyers that you can consult with. That have other benefits to all this. We deal with some of the incubators around Vermont in our work here. We find them, I think, on the whole, useful for people. And not rapacious in wanting too much participation going forward. But one does want to be a little careful with that. That can be a resource. Nicole, would this be a time to jump quickly to resources we can supply? I know we've got another slide.
Sure. Yeah, so we're the Vermont Small Business Law Center and Clinic, where we operate out of Vermont Law and Graduate School. And one of the things that we offer is not just a group presentation, but a one-on-one educational call if you want to do it, if you want to do a deeper dive on some of the questions that you have. We can do that. We could also offer up to 10 hours that we pay through a grant to an attorney. We can help you find an attorney, and we can pay up to 10 hours just for general business needs. There is also, and that's part of why we're doing this program, is that there's the State Small Business Credit Initiative, SSBCI. This program, again, is supposed to bring capital into the states, and there are several different people holding the capital to hand out. There's some venture capitalists in Vermont that are holding it, and there is VITA is going to take another chunk of it back. So it's for low interest loans. That program, if anybody on this call is interested, I would like you to please email us at sblc@vermontlaw.edu. Putting that in the chat. Oh, sorry, I'm in the waiting room chat. Wait a second, I don't want to talk to the waiting room. There's nobody there. If you're interested in SSBCI, what comes along with it is not only the capital transactions that they're trying to encourage, but also technical assistance services. So accounting, financial, and legal services that come along to support an SSBCI transaction. Keep that in mind, especially if anybody's looking for investment or taking on debt of some sort. That provides some attorney's fees that can support those transactions above the 10 hours that we offer just to everybody. I think that's it. Do you want to go on to the next topic?
Yeah, let's go to the next slide, because
okay, we can wrap it up, and then I'll have you guys take a survey if you're willing.
Debt
how we can
versus
help you in the
equity.
future.
What are we going to do here? And
Yeah.
we as lawyers have our particular view. The approach is a little different. Debt can be riskier in this taking on debt, but it can also limit the participation in the upside. In an up market, debt is your friend, because you've defined the return you have to give to somebody else, and you didn't give them a piece of the whole pie. But also they have to feel pretty secure that it is going to be an up market, and so it's not always available. It's not risk money typically. Equity has that bigger kicker to it, that you just agreed to take on somebody else to give them a lot more money than you would have if it's a success, than you would have if it was debt. But on the other hand, you don't have to repay them if it fails. So it's you've limited your downside, and also people in a very speculative enterprise may want that big upside. They're not saying, hey, I couldn't lend it to you. You should be aware that sometimes people will come to you and say both. They're saying, hey, you need $5 million. Fine. I'm lending you 4,500,000, and I'm investing 500,000. And for that investment, you're going to give me a third of the company. And you say, but it's only equity.
Ouch.
Ouch. Well, hey, you want my money?
Yeah, right. I
I'm
guess
not
so.
I'm not in this for philanthropy. I'm in this to
Yeah.
gouge everything I can out of deals.
Yep. Pretty much.
There we go. Go back and see the movie Wall Street or whatever it is. You know,
Yeah, right.
yeah.
Cutthroat.
It's it's a little cutthroat. Folks are not your friends. They may be your allies, but they're not your friends. Yeah.
Yep.
So just be aware of that, and that's all right. I mean, you get into business with folks, that's it's business, and you want to have it well defined. You want to know what it is. You want to understand what your risks are, what your upsides are, and you want to go into it with eyes wide open. And if it works for you, fabulous. And if it doesn't, shame on
That's
me.
business.
There we go.
That's business too.
So, any questions on debt versus equity? Again, that's a pretty general level. I would evaluate. What's the business case for each one? What is going to be the risks and limitations? What are the lawyer pieces on it? And then really come to some kind of conclusion to that. Any other thought on that? Nicole, do you have any other thought on?
No, I think that if one is in a position to be able to take on equity, it's awfully tempting. Just remember what's at the other end of the road, because folks often tend to lose sight of what's at the other end of the road when they take that on. And just know that at the other end of it, because I used to do collections, at the other end of debt is also collections. And if one cannot pay debt, then that looks, come and talk to us. We can help figure that out too. But if one cannot pay debt, collections comes into play, and that means taking secured collateral, possibly bankruptcy, and it gets pretty messy. That's what we didn't cover, because we wanted to talk about the upside about this stuff. How do you make money? That's all I would offer, though. It's really, there's a lot of decisions to be made. Like you said, there's a lot of different issues to be considered. I'd like the framework that you set out there, Oliver, because it really checklists go through each of those things. What is the case? What's the business case for each, as you said? Compare them.
And be aware that lawyers can craft pretty broad swaths of opportunities and risks in the documentation.
Yeah.
LLC versus corporation. This one, again, is particularly for on the equity side, but even on the debt side. Both on the debt side, the LLC and the corporation offer somewhat similar protections for the owners in the terms of the limited liability piece. In terms of the equity piece, again, we can draft around and get to moderately similar results with an LLC or corporation. The corporation is typically used in circumstances where there's going to be a lot of investors, where there's going to be a kind of a venture capital style piece, where there's going to be a national presence. These kind of an expectation of a corporation in that kind of context of funding and operations. LLC is much more if it's going to be only a few investors, if it's going to be a negotiated deal, if it's going to be a more local character, that kind of thing can lead to it being the LLC. Cole, would you add to that?
I think I just remind everybody of how to position oneself. I think that's what I really run into. But when you look at larger deals, you better have everything in hand, because if you don't, you're probably not going to get the money. There is a process that we warn people about, which we didn't really talk about, which is just the due diligence that happens between initiating a deal and closing on a deal. And that the due diligence process in and of itself, to take on especially a large amount of money, shows a person where all the weak points in their business is and where they need to clean things up.
Yeah, it's a little bit like inviting someone in who's going to rent or buy your house, and they come in with the white gloves and say, where's the dust? Where's the dirt? What piece of plumbing isn't working? And I again, I don't mean to over personalize, but I've just been through a pair of transactions in the last 6 months, an equity transaction and then an exit transaction, and in both of those, the due diligence was months and months, and the lawyer fees involved with those due diligence months and months were hundreds of thousands of dollars. So
that's even with you doing some of the work.
Yeah, exactly. So it's very significant. One of the things to try and do is actually keep good records from the start. Keep good records from the start. That's a big piece of it. Make sure that the personal and the company are separate. Make sure that all the records are there. Anytime the money comes in, anytime the money goes out, use those QuickBooks. Use it with some religiosity, and make sure that the accounting is clean, well tracked of, etc.
And if you're an LLC, please have an operating agreement. That's my last request.
Yes. Yeah. Strictly speaking, if from a legal standpoint, they're not always necessary. They're always useful.
Always useful.
Yeah.
We can take any last questions, guys, because the last thing that I need you to do, well, the last thing we have for you is this giant QR code here. Any last questions, though, for anybody on anything?
You mentioned that the LLC was something maybe you'd take advantage of more when the company's dealing with more local product. If you're selling a product internationally, is there a reason not to use an LLC?
No. If LLC is perfectly fine in that context, it's really more a question about what are the expectations on it, and if a local product is being sold internationally, cool. I mean, if it's a maple syrup farm and it's set up as an LLC and it sells, the odd pint and gallon to folks in Spain, cool. It doesn't really make much difference, but much more, it's more the question of the expectations of people dealing with the company, either as investors or as customers. That is it going to be an LLC or is it going to be something more broad? And sometimes it's a mix. For instance, often the parent company may be a corporation, a C corporation, and subsidiaries can be set up that are also LLCs. That is a structure you'll see. Joint ventures, even at the top level, are often LLCs. The company that used to be Chrysler Motors, I'm forgetting what it's called at the moment, is, I believe, an LLC at this point because it is an American subsidiary and to some degree a joint venture between a couple things. So again, that's an example of a very significant company that's an LLC.
Yeah.
But again, it isn't so much the legal restriction as it is the expectation piece.
Yeah.
I have a question. So
Yeah.
can an LLC own a C corp?
Yes.
Okay.
It cannot own an S corp, typically.
Okay. So
I did not know that. Interesting.
If I have an existing C corp, is there a way to create a parent company and then have that parent company own it, or if the existing company has to be the parent?
Without commenting directly on your question, one of the techniques that could be used sometimes in setting up an LLC to sit on top of a corporation would be for the owner of the corporation to donate the stock to the LLC and have that be then the equity contribution that entitles that owner to now a membership share in the LLC. Doing that may have tax implications. So before anything, doing that, make sure that the tax implications are fully explored, because it may or may not be a recognition event with respect to the tax. It may not be, depending on but it may. So, and then the basis in the contribution will be limited to the basis of the company that was given. I mean, there's a whole set of moderately complicated tax issues that should be cleared up before that goes forward. But from a more legal standpoint, just the standpoint of corporate law, LLCs can be owned by corporations. Corporations can own LLC.
Okay, thank you. That's perfect.
Yeah.
Right. Do we have any other questions? I can explain this slide here. And as you can see, my daughter is losing her patience. She's been very, very patient. On the slide here is a QR code. This takes you to a short survey that we ask folks here to fill out. This is just our post-event survey. It asks for a little bit of feedback. What did you find useful? And it also asks how we can help you in the future. We have an intake that allows you to set up. Please, I'm on a call. We have an intake, but it is down right now. So we are going to, if you want to be considered for services for us, meaning the educational consult and the 10 hours with an attorney that we can help you find, or if you're interested in SSBCI as well, please email us at this email address that I've put in the chat here. I'll put it back up here. This is how you reach us right now. We're just struggling. What is that? I put a slide. Shoot. I had a slide apparently on my, sorry guys. This allows us to help, well, both reach out to you when our intake is fixed, if you're interested in submitting an intake, and also if you're interested in SSBCI, we can get you going with that. You'll have to go through the Small Business Development Center first to talk to them. So please fill out the survey if you're willing, and it also asks if you previously submitted an intake and if we can help you if you're ready to work with an attorney. If you think that it would be useful for us to help you going forward, please go ahead and fill this out for us. Any last questions or comments?
Well, yeah, quick for them, but also just, it's complicated. We've tried to do a quick romp across a lot of complicated stuff. Come talk to us if you'd like some more education. get a lawyer if you and also read up yourself around. But hopefully this gives you at least an entry point for a lot of these questions. I know some of you have experience and may have already known a chunk of this, but hopefully it will be helpful.
Yeah.
But that was preempting other people's questions or thoughts. Either of the Jasons, the Stephen and the anonymous
Mr. 323.
phone number.
Anybody have questions? This is your chance.
No question. Appreciate you guys' time.
No problem.
Great.
All right. Cool. Well, thank you. We will have this recorded. We're going to put it up on our website. We have, if you're interested, we have a library of other topics that we've done presentations on. So you're welcome to go browse that. They're all free. And we'll put this up on our
Intellectual
YouTube page
property,
Yep.
other issues.
We've got IP, we've got entities, we've got other presentations on limiting risk for your small business. We have a couple of deep dives on things like commercial leases and other topics. Really, we've got a pretty good range there of educational topics. So feel free to browse. And thank you so much for coming to this presentation. We appreciate it. And thanks for asking the questions that you did. We love the questions.
Good. And Nicole, you want to give me a quick call? Why don't you?
Yes, I'll give you a call.
Thank you, guys.
Thank you very
Thanks,
much.
We can just hang out here.
Okay, we can do that. Okay, good point. I just wanted to just say, hopefully that worked well. Just any debrief on.
Yeah.
Oh, did you turn off the recording? Turn off the recording.
I did turn off the recording. Wait, hold on.
No, it says it's recording.
Stop recording. Yes, I want.